Good morning, everybody. Good afternoon. Sorry, it's just gone 12 o'clock. The day gets away pretty quickly. Thank you for joining us today. It's the first time we've done this format, actually. So we've just finished our breakfast seminar series around the state. Everyone here is from New South Wales and ACT. This is not one of our national webinars that we've done in the past. Now, I guess we've sort of lured you here a little under false pretenses today, because at the end of this event, we're going to have a survey for you to fill in. And what this is, we're trying to make our website a little bit better. We've got lots of great content on there, but it's hard to find sometimes. So we're going to ask you, what would you type into Google in certain scenarios? So if you could please give us that feedback as we go along. Brendan Giles here on my right. Most of you know him or will know of him. So he's going to do the first part of today's seminar, and then I'll take over from halfway and bring it home. So I'm just going to share the screen now, and hopefully you can all see that. And I'm going to hand over to Brendan to get us started. Thanks, Brendan.
Good morning, everyone.
Afternoon.
Afternoon, everyone. I'd say some solidarity. Welcome. Thank you all for joining us. Today we'll be talking about asset exposure from the unique perspective of insolvency practitioners. With the economy starting to trend a bit down and things getting a bit more difficult for business, we thought it was a good time to look at some strategies that business owners can use to protect their assets in the event that things go wrong. So before we kick off, a quick disclaimer, everything in this presentation is by way of general information only. If you need any specific advice in relation to you or one of your clients, please reach out to one of Worrells principals around New South Wales directly. So what we'll be covering today, 5 topics. First, we'll have a quick look at the insolvency landscape and what's going on with insolvency appointment numbers and the ATO's debt recovery activity. And then we'll be looking at some limitations of the corporate veil. And then Aaron will jump in and look at some tools that trustees in bankruptcy have for disrupting asset protection strategies in the event that something does go wrong. I'll look at some case law, and then finally wrap up with a look at what actually works. So the protection strategies, the asset preservation strategies that we think are the ones that are the best to work with. So first, look at the insolvency landscape. And we'll start off with corporate insolvency, which is pretty much back to pre-pandemic levels at the moment. After a couple of very low years during the pandemic, as things like JobKeeper and JobSaver did their work and kept businesses afloat, numbers were very low, but they're slowly rebounded. And a lot of that is on the back of ATO collection activities. Total collectible tax debt for the ATO is still at $44.8 billion. But we got a recent update that it's looking to be close to $50 billion by the end of this year. So they're not actually bringing the debt down at the moment. They're just chipping away, but the pile is growing. They are stepping up their collection action, though. They're currently issuing 60 directed penalty notices a day, which is double what they were doing last year. They're expecting to report 2,500 businesses to credit agencies this financial year, which is 5 times what they did last financial year. And they're currently filing about 140 wind-up applications a month on average. That's a long way short of their old pre-pandemic average of around 350 a month. And it's nowhere near the more than 500 a month they were doing in the post-GFC period. So there's going to be more, given the amount of debt that's outstanding. There's going to be more movement by the ATO there, and we expect those numbers to jump up. Winding up applications are pretty much back to normal levels, with the exception of the ATO's wind-up activity. So everyone but the ATO back to where they would have been, especially the bigger banks and those kind of those kind of creditors are back in the wind-up space, and it's just the ATO that needs to catch up to traditional levels to get wind-up numbers back to average, and we expect that they'll probably exceed that average going forward. Looking at small business restructuring, which is, again, a relatively new thing, although we've talked about it many times. It's starting to really jump up in popularity. We're seeing directors prefer it as an option because it is cheaper than traditional voluntary administration, and they get to stay in control of their business through the process, which we find a lot of directors, the thought of handing over their business for a period to someone else to run is quite intimidating, and the ability to stay in control while we go through restructuring is very popular. At the moment, we're looking at over 80% success rate for small business restructurings across all of them done. That's a number from ASIC. In Worrells, we're at over 90% success rate, so a bit better than average. And the ATO remains very supportive of this type of appointment. They keep encouraging us to go out there and bang the drum, which is why we're talking about it now, to get more people and more businesses to do these kind of things to deal with their historical tax debt.
And don't be shy. What's our success rate so far, Brendan, in our team?
In our team, 100% in our team, yeah.
Not bad.
Haven't had one knocked back yet. They are held back a little bit at the moment by some difficulties around the eligibility requirements, and in particular, we're finding unpaid super is a bit of an impediment for some small businesses. And there was a recent insolvency inquiry by the Senate that that was a key point that got brought up, that we need to broaden the availability of small business restructuring just to get more businesses involved. On the bankruptcy, personal insolvency side, personal insolvencies went down, similar to corporate insolvencies during COVID, and they've stayed very, very low. There's two main reasons for that. First is that unemployment is very low. Employment's strong. When people have jobs, they tend to not go bankrupt. They can stave things off for a bit longer. And there was a bit of a change in the way that the consumer creditors collected debt during COVID. They went from being a bit more aggressive about collecting their debt to allowing consumer creditors to enter into low-value payment plans over long periods of time. And often these payment plans will never pay off the debt. They're just something to keep them chipping away at it. And since the pandemic's ended, a lot of those plans have just stayed in place. They've stuck with that process, and they haven't gone back to the more aggressive pursuit that they were doing before COVID. So it remains to be seen whether creditors will return to a more aggressive approach, or whether they'll stick with this sort of payment plan approach they've got now. Because if they stay with that, personal insolvencies will probably not return to pre-COVID levels. So what we see going forward, we've really seen a sort of two-speed economy over the last little while. There's been a bunch of tailwinds pushing businesses and helping the economy along, and then some headwinds that have been sort of blowing the opposite direction and slowing things down. And we're starting to see those headwinds exceed the tailwinds. And so just looking through the major drivers, we've got the lingering effects of COVID. What we like to call the COVID hangover for businesses that ran up debts during COVID that they can't, deal with. And the best way to deal with a hangover is to keep the party going, and that's what's been happening. We've had a really strong economy. Retail sales have been at record levels, and that's allowed businesses to ignore that hangover and just keep cranking on. But those retail sales and that economy is starting to slow, and so that hangover is going to catch up with a lot of businesses, and they're going to need to deal with those legacy debt problems. We've got high levels of household debt. They're not quite at record levels, but they are very close to record levels. But we've also had record household savings. During COVID, people were able to squirrel away money. They got extra money from things like JobKeeper, and also it was hard to spend money because you're stuck in your house. And so those savings have propped up that record debt, even as that debt has got more expensive. But those household savings are a finite resource, and they are starting to get eaten into. And once they're exhausted, they're gone, and you're just left with the high level of debt. We've got cost of living pressures. Anyone who's been to the grocery store or got an electricity bill recently, unless you have solar panels, you will have noticed that cost of everything has gone up. That's been somewhat offset by record low unemployment and household incomes, which have pretty much kept up with the increase of cost of living. But again, unemployment's likely to rise. The RBA thinks it'll rise to about 4.5%, and with less pressure in the employment market, that income is going to start to fall, and cost of living pressures are going to start to bite household budgets more seriously. And then finally, we've had rising interest rates. The RBA has been pushing up rates to deal with inflation, but the actual rate people are paying is still comparatively low. We still have a lot of people on fixed rates that haven't rolled off yet. We still have a lot of businesses on fixed facilities that haven't rolled over to those higher rates. And so over time, the impact of those rates is going to be felt more. And so what we expect to see over the next 18 to 24 months is insolvencies are going to start to rise. We're going to see a bit more difficulty in the business community.
Just quickly before you go on, I'll just jump in there. There's 183 of us in attendance. Just on the right-hand side of your screen there, it's a Q&A button. So if you've got any questions, I'm sure there's going to be some questions out there. Please pop it in there. If you wonder why I keep looking down at my laptop, that's the reason. I'm just monitoring your questions. So please pop that in as we go.
All right, so first we'll look at the corporate veil. So the corporate veil is a protection that's provided to directors and shareholders of a company that limits the liabilities that can transfer from the company to those officers. And there's a bunch of limitations to that veil, and they typically arise from one of three reasons. First, that the director voluntarily forgoes them, so they sign a personal guarantee or something like that. There's a legislative mechanism that provides for a claim to get through or around the corporate veil, or the director's conduct, something they do, pierces that corporate veil. And it's important because a lot of directors and people, as they go into business, they don't really understand the personal risks they're taking on. They're often mostly focused on the benefits of this new business. They're excited. They're looking about the huge money they're going to make, and the big house and the fancy car they're going to buy. And they're not thinking about, if things go wrong, what are the risks and how do I deal with those risks? And so they do things that aren't always the most sensible asset protection strategy. And so it's good to be aware of the things that can limit the corporate veil, just so that your clients are aware of them and can take action accordingly. So the first and major one from an insolvency practitioner's perspective are insolvent trading claims. And so this is a claim that a liquidator can bring against a director where they have traded a company whilst insolvent. So that means the company is unable to pay its debts as and when they fall due, and they've just continued to trade and continued to incur more debts. And that is a claim against a director, so a director who is registered on the ASIC database, and they can be executive or non-executive. It's also a claim against shadow or de facto directors. So they are people who act as a director, so they're involved in the management of a company, but they're not registered as a director. And it's also, it doesn't matter if you're an active or inactive director. So directors who aren't directly involved in the business, and we see this a lot, where mum, dad, the wife are the director of a company, and it's actually the son or the husband who are actually running the business and are really, the controlling mind of that business, but they've looped, their wife or their significant other or their husband or whatever into liability by having them listed as a director. And the claim arises, Section 580 AM, so it's a damages claim that's equal to the debts incurred when the company was insolvent. So we work out a date when the company became insolvent, and then any debts that are incurred after that date form part of the insolvent trading claim, and we have a claim for damages equal to that amount. There are some defences available to directors, so they can argue they had reasonable grounds to expect the company was insolvent and will remain solvent. They can say that they relied upon a competent person, so they got advice from someone, and there's some big limitations to that defence that we'll look at in a second. You can say that you were ill or you had some other good reason. The other good reason that I've come across that was successful was off having a baby. Or that you took reasonable steps to stop the company incurring that debt and weren't able to. So looking at the common occurrence of directors being passives, this is a case, Morley versus Statewide Tobacco Services, and Mrs. Morley was sued by a creditor rather than a liquidator. A creditor can also take an insolvent trading action. And she was a passive director. This was really her son's business. She'd stepped in as a director because there'd been previous issues with him as a director in the previous iteration of this business. And the business had gone bad again, and she was on the hook because she was registered as a director, and she ran two defences. The first was that she hadn't been involved in the business incurring the debt. She'd not given any express or implied consent. And the second, that she had reasonable grounds to expect the company was insolvent because she knew nothing about it, which is an interesting argument to make. Neither of those grounds were successful. And the court held that as a director, you have a positive obligation to be aware of the financial position of a company that you're a director of. You can't just say you relied on someone else. It's not my problem. And so you've got to be careful with these situations where we have.
Got a question here, actually, Brendan. To what degree is it insolvent trading? Are there any ratios or how long or how big the debts need to be?
So insolvency is a very simple question, but also a very complicated question. So the simple answer is if a business cannot pay its debt as and when it's fell due, it is insolvent. But it's whether it's able to, not whether it actually did. And so you've got to look at the resources available to a business at a time. And so it can, owe $100,000 and have $100,000 in the bank, and at that point it's not insolvent. But if the bank account drops to 50 grand and it still owes that $100,000 because they bought something or spent some money elsewhere, then now it's potentially insolvent. And so it is a sort of complicated issue, and there are lots of indicators for insolvency. There's a landmark case, ASIC v. Plyman, that gives us 14, I think, indicators to look at. Now, one of the key issues when we run one of these cases is actually proving the date of insolvency. It's not a very straightforward process. But as a general idea, when you talk to, especially to small and medium business owners, they have a good idea of when their business is insolvent. They can sort of pick the point where, okay, I've got no way out of this. I can't afford these debts anymore. And usually if you talk to them and they're honest with themselves, they know the situation.
The second part of that question then, how to get the debts. Look, there's a real commerciality issue here. Frankly, it costs a lot of money to run insolvent trading procedures, and it costs a lot of money to do those detailed investigations. So unless it's for a significantly large sum of money, we won't incur the cost.
So another case, just looking at directors being passive, and this is a side case to that ASIC v. Plyman case that I talked about before, which is John Elliott v. Waterwell Holdings, and this deals with relying on advice. So Mr. Elliott was a non-executive director of a listed company. He relied on the advice from the accounts team, so the CFO and the accounts team, to show that the company was solvent. They provided him with financial statements and other records. And that was his defence to the insolvent trading claim, and that he was unsuccessful with that defence. The court found that as a director, he had a proactive responsibility, not just to get that information, but also to inquire and make sure that it's correct. And he didn't do that. And in this case, if he'd looked into the accounts receivable, which are a large portion of the company's assets, it would have very quickly become evident that most of those accounts receivable were fictional, and the company was very insolvent. And as a result, he had a damages claim against him of $1.4 million. So it can be a significant amount of money if you don't get this right. So mitigation strategies for insolvent trading, there are a couple. The first is appoint an insolvency practitioner early. The closer to that insolvent trading date that you get the company into liquidation, or you enter into something like voluntary administration or small business restructuring to solve the solvency issue, the less the potential claim is, and the less likely it's going to be commercial to pursue. Secondly, you can stop incurring debts or limit the debts you incur, because it's a claim for incurring debts after that date. So if you move to cash on delivery with your suppliers, you don't borrow money, those kind of things, you also limit the claim. And there's also safe harbour provisions which were provided in the Corporations Act, which allow directors to claim an exemption for insolvent trading for a period when they are under the safe harbour. And that means they've entered into a plan or a course of action that's likely to lead to a better outcome for the company and its creditors than if it went into administration or liquidation. So what this allows is for businesses owners to try an informal turnaround of their business. You need to go through some steps. You need to have a plan that needs to be documented. You need to keep all your books and records up to date during the period. You need to make sure all your tax lodgements are done on time and paid. You got to make sure you've properly provided for employee entitlements, so you've paid your super and you're paying employees properly. And you've got to obtain advice from an appropriately qualified restructuring advisor, and they need to confirm that it's reasonably likely to lead to a better outcome. And if you do all that, you follow the process and it doesn't work out, the company ultimately fails, the directors then have an exemption for that period from insolvent trading claims. Another common thing we see is debit loan accounts. Often, especially smaller businesses, directors don't differentiate between their own bank account and a company bank account, and they will just take money out and use it for their personal things. And usually this gets categorized as a loan account in the company accounts. Often these accounts are not dealt with. Sometimes they're recategorized as dividends, or they're recategorized into a proper Division 7A loan account that's documented. But most often, nothing happens. They just get sit there and keep accruing. And when the company goes into liquidation, the director now has a problem because he has a significant debt that he owes to that company that needs to be repaid. And it's a claim against that director that the liquidator is required to pursue. There are some mitigation strategies to deal with this. The best one, and it's not always palatable for cash flow reasons, but is to just pay the director a salary. Make sure your PAYG is deducted, make sure the super is remitted, and that is very hard for a liquidator to pursue in the event the company fails. Another one is to declare a dividend, ideally monthly, that flushes out that loan account. You just need to be wary of Division 250 or Section 254T of the Corporations Act, which specifies when you can pay a dividend. So you need to be in a position where the company has sufficient money the company has sufficient funds to pay dividends. So you've got to make, and also the payment of the dividend cannot jeopardize the ability of the company to pay its creditors. And if you do pay a dividend in circumstances where there's not sufficient funds available, or it's going to jeopardize the ability to pay its creditors, that dividend becomes a voidable transaction the liquidator can claw back. I've seen that happen on many an occasion.
I've got it. Just go on to the next one.
Yep.
We've got a question that's come in relation to safe harbour, asking whether a chartered accountant is an appropriately qualified restructuring advisor. I don't know the answer off the top of my head. I think it might be.
My understanding is that it's not defined in the Act. The general position from ARETA, which is Australian Restructuring, Turnaround and Insolvency Association, is that you have to have completed their restructuring and turnaround course, but that is a bit self-serving of them to say that. But there's no real guidance around that. There hasn't been a case where the qualifications of the restructuring advisor have been challenged to have a definitive position. I
think to an extent it's going to be determined by the individual factors as appropriate to each client and each company. You will know yourself whether the issues are within your field of knowledge. Another question, does a monthly dividend look like wages for workers' comp insurance? Good question. I don't know. I don't think so. No, I don't think a dividend is wages. I mean, we do it in our business. Pay dividends every month, and it's based on percentage ownership of equity. I can't see how that can be mistaken for wages. I don't know for sure, but I'd suggest the answer to that is probably no. Yeah, I'd agree. Another risk, we'll talk about the ATO ramping up their collection action, and director penalty notices are the key tool they're using at the moment. While no DPN is good, there is a good type and a bad type. The good type is a non-lockdown DPN, so that means you've lodged all your BAS and super guarantee charge statements on time, and that notice, should you receive it, gives you 21 days to take an action to remit the penalty or cancel the penalty. So the director has no liability if they take action. The lockdown DPNs are the bad one. They're issued when a company has failed to lodge their PAYG or IAS within 3 months of the lodgement date, or the SGC statement by the due date. And they lock down a director, so they immediately make the director personally liable for the penalty equal to the tax owed by the company, and there is no way out except paying the debt in full. So mitigation strategies with these are just lodge on time, even if you can't pay. The worst case then, you'll get a non-lockdown DPN and you have that 21 days to take steps to remit the penalty.
The other key thing that we're seeing lots of directors get caught out with on DPNs at the moment is DPNs are issued by post, and they are issued to the address for the director that is registered with ASIC. So not the company's registered address, not the tax agent's address, the actual personal address that the director has registered with ASIC for that company. Lots of people do not go into ASIC and update these addresses when they move. And we're seeing lots of people get caught out because they don't find out about the DPN until long after the 21 days has expired, or the first time they see it is it's expired and the debt's been transferred onto their personal tax account on MyGov. And so, it's a good process to just get in with your clients and do an ASIC search and make sure they've got those addresses up to date.
A couple more questions here on DPNs. For time, I might just, Chris, you've already had one, so I'll jump to Helen's. The options available to a person if they're an ex-director and they receive a DPN years later.
So
there's really none.
Yeah, you're really in a difficult position there if you are an ex-director and receive a DPN years later. I mean, you can go back to the company and see if you can get them to take any of the steps under the DPN. But failing that, you're really out of luck, unfortunately.
Mm. Yep. The current directors are going to have the same problem though. So if the issue giving rise to the DPN hasn't been rectified by the current directors, then they're going to get the DPN as well. So I guess you've all got the same best interest at heart in terms of taking one of those 4 actions that's available.
Another little known risk, if you're not an insolvency practitioner, is the ATO's indemnity provisions for preference recoveries. So in an insolvency situation, a liquidator has a power to recover what are called unfair preferences. So these are payments in the 6 months prior to appointment that prefer a creditor. So one creditor gets more than they otherwise would have gotten if that money had just stayed in the company and they participated in the wind-up. And the entity that receives the most preference payments is the ATO. Directors see the DPN risk. They pay the ATO a bunch of money before the company goes into liquidation to mitigate that lockdown DPN risk. And then the liquidator goes and claws that money back as an unfair preference. And then the ATO has a statutory indemnity under Section 5A FGA of the Corporations Act to turn around and issue a bill to the director for the amount they have to disgorge for a preference. So in order to affect this, the ATO requires an order from the court. And often in preference recovery actions, we will settle claims with the ATO, and as part of that settlement, they'll require us to just file proceedings, and then there'll be consent orders just so they can access this indemnity.
That happens far less often than it used to, because if we do that, then we have to join the director to the proceedings because they've got an interest in the outcome. So it doesn't happen very often just because of the expense involved.
Yeah, but it is a risk, and it's one of those issues where sometimes you can't avoid all risk, and if you've got a lockdown DPN risk and an indemnity preference recovery risk, it's a matter of sitting down and working out which risk you'd rather take. Personal guarantees, we're frequently seeing directors voluntarily give up their corporate veil protections by entering into personal guarantees. They're usually attached to credit applications. I think the vast majority of directors don't read those applications. They just sign them and aren't even aware they're giving personal guarantees from the number we talk to. A lot of them are increasingly including charging clauses, which allow caveats or even registered mortgages to be registered over the personal property of the directors. And in most cases, directors just don't have any idea what personal guarantees they have signed. And that is a significant issue, especially if they're looking to do a small business restructuring or a VA, deed of company arrangement on a short time frame because they've got a DPN. Because one of the issues with either of those things is you're not paying debts in full. You're reaching a settlement to pay a portion of the debt. 30 or 40 cents on the dollar is a sort of typical outcome for an SBR at the moment. And that means there's 60, 70 cents left that the director is going to have to deal with under their personal guarantees. And we need to know, when we're putting together a plan and working with them to work out how much money they need and where that money needs to go, what those personal guarantees are. And it can be very difficult sometimes trying to work out what's guaranteed and what isn't. Some of the mitigation strategies you can take, first, just don't sign personal guarantees. Often we found suppliers will actually compromise and are willing to waive those clauses, sometimes for smaller credit limits and things, but a lot of suppliers are flexible about the personal guarantees if you just talk to them rather than just signing the document. Look at limited bank guarantees or cash deposits as an option instead of a personal guarantee, especially on property leases, so you're limiting your risk there to the bank guarantee. Look at restricting your guarantees. So you include specific property. So you might risk the investment property, but keep the principal place of residence excluded from the guarantee. And make sure you keep a register of personal guarantees so that if something goes wrong and you need to work out what the position is, there's a nice list that you can sit down. You can put the current payable amounts for each of those in and know what the exposure is. Loan accounts or secure credit loan accounts are another area which is really a more recent issue. During COVID, lots of businesses got into trouble, and at the same time, real property values were going pretty well and interest rates were low, so it was easy to borrow money. And we saw lots of directors pull money equity out of their house and stick it in the business to keep business going. What they've done there is they've transferred a liability onto their personal selves for the business. So they're liable to repay that mortgage no matter what happens to the business. If the business fails, they're an unsecured creditor. They're right down the bottom of the tree, and especially in small and medium business insolvencies, it's unlikely that they'll get any sort of significant dividend as an unsecured creditor. There is a way to mitigate this, and it's securing those loans when they're made to the company. So anytime a new advance or a loan is made to the company, or if you've got a rolling facility where you're providing cash flow to a company, you can set up an agreement. You need to first enter into a contemporaneous agreement, a loan agreement between the director and the company. You need to enter into a contemporaneous general security agreement that goes with that loan agreement. And then that GSA needs to be registered on the PPSRs, on the Personal Property Security Register. And that means that the director now has a secured claim over all of the assets of the company. And that puts them above all the other unsecured creditors. It means they're much more likely to get their money back in the event the business fails. A few other quick hits. So failing to discharge your director duties is a very common issue. We see in the Corporations Act, there's a whole bunch of directors' duties from section 180 to 184, I think it is. Most directors are not aware of them. They breach them all the time, and every time you breach a director's duty, it gives rise to a potential damages claim. Commercial and unreasonable direct-related transactions. These are transactions that a reasonable person in the director's position would not have entered into. But these are often transferring assets to themselves, buying themselves an expensive car, those kind of things. They're easily avoidable transactions that can get directors into trouble. And the final one is creditor defeating dispositions, which are a relatively new piece of law. They're designed to deal with Phoenix activity. So the traditional Phoenix is you have a company, which we'll call Oldco. It has a bunch of assets in a business and a heap of debt in it. And you have a Newco, which has no debt. And you just transfer the business and all the assets to Newco, wind up Oldco. If you do that now and the Newco does not pay market value for the property or the best price that would be reasonably available given all the circumstances, and the transfer has the effect of either preventing the property from becoming available to the creditors in the liquidation, or hindering or delaying that property becoming available, then that becomes a voidable transaction that the liquidator can undo and take that property back. And the best thing about this provision from our perspective is we don't need to go to court to get an order to transfer the property back. We can get an administrative order from ASIC. So rather than running off to court, incurring costs of lawyers and barristers and all that expense, we can make an application to ASIC. They give an administrative order, which requires the transfer of the property. And then it's ASIC's job to enforce it, not ours.
Before we move on, I've got a quick question here from Ross, which is in relation to joint and several liability for the personal guarantees. So going back a couple of slides, personal guarantees. Yes, we do see this a lot where we've got two directors. They are jointly and severally liable. They seem to assume when they come and see us that they each owe 50% of it, and don't realise that they actually each owe 100% of that debt. And then from time to time, what we see even going beyond that is one of them pays most or all of that that debt, and the other one thinks they've gotten away scot-free only to be sued or have some claim or request for the co-contribution by the other director. So often a cause of dispute between business partners as well, just to compound the risks that are involved, I guess. All right, so look, just before we move on, I want to just lean on you all for a moment just to provide us with a bit of feedback. And I know Aggie's listening in here. Aggie, we're going to be a little bit over time, I think. So if you could extend the time available for this webinar for some of these the questions, the polls and surveys and stuff. But if you could all just quickly click on that survey thing on the right-hand side of the screen, and then there's a little button there to take a survey. As I said at the start, not all of you were here at the start. What we're trying to do is find ways to make the information that's on our website more accessible to you and easier to find. There is a hell of a lot of information on there, and it's not the easiest in the world to navigate. So we're trying to improve that. So what we're asking you to do here is we've just given you 3 quick scenarios, and we just want you to let us know what are you going to type into Google to find those scenarios, and that's going to help us know what headings we should use for this information, ways to make it easier to find through search functions, but also easier to find and navigate to on our website by knowing what terminology you use. So the first one, we've got a client who's come to you with a director penalty notice. The company's got some other debts that had accumulated over COVID, but the business is now trading profitably and has done for the last 12 months. So if you're looking for some help from an insolvency practitioner on that, what are you going to type into Google? The next one is a creditor's got some, a client of yours has a creditor who's commenced legal proceedings in relation to a debt that they dispute. If the claim's upheld, that's going to make your client insolvent, and they don't really have enough money to fund their legal defence. It's going to be quite expensive. You're looking for some advice on that. What are you going to type into Google? And then third, you've got a client who's hopelessly insolvent. They just need to appoint Brendan Murray as liquidators because it's beyond repair. What are you going to type into Google to find some help there? So if you could all just multitask and take a few moments to answer that for us, it would be very much appreciated. I might hand this over to you, Brendan, to monitor the questions for us. Looks like we've had another one while I'm talking as well. A few more. Oh no, same ones. No. Okay, so I guess
so it's a lockdown DPNs and the ATO's lodgement amnesty. They do conflict. That's again, it's a risk mitigation thing. We decide whether you make those lodgements under the amnesty and risk the lockdown DPN, or whether you choose not to make those lodgements and wind up the company instead.
All right, I'm going to try and shortcut this next section because the last bit's more interesting because we are running out of time. So far we've discussed the position with respect to directors and their possible implications upon them if a company faces financial difficulty or it gets placed into liquidation. But what happens when those risks then materialise into some director liability and then that director needs to become bankrupt? How are those directors' assets and their asset protection strategies exposed to the bankruptcy trustee? And we've got lots of powers as bankruptcy trustees to disrupt and undo asset protection structures. Before we move on to those, it's probably worth having a very, very brief look at what assets are available to a trustee in bankruptcy. And the quick answer to that is everything. The law says that all property vests in the trustee, but then it has a few sort of limitations on that. Firstly, tools of trade, and that's up to a prescribed value of $4,200. That's recently indexed in June, that number. Motor vehicles. Now, the motor vehicle has to be a primary means of transportation. In order to be a primary means of transportation, it needs to be registered. You need to be able to use it for transport. So it can't be a track bike or a track car or something like that, or a dirt bike. It's not registered. It has to be primary means of transportation. And in order to be primary, by definition, there can only be one. So you can't have two vehicles worth $4,500 each and keep them both. Threshold value on that's $9,100. Superannuation doesn't vest in the trustee. We might come back to that. I'm going to jump forward a few slides and talk about superannuation in just a moment. Compensation for personal injury, and interestingly, any money that a client receives as compensation for personal injury, if they convert that into an asset, say they buy a house, it maintains its nature. So that by converting it into another asset doesn't make it available to the trustee, and then your necessary household property. And I guess on that list as well, we've also got property held in trust. So that's property which isn't beneficially owned, and so therefore doesn't vest in the trustee. Nor do the if it's a discretionary trust and the bankrupt is also a beneficiary, the rights of the trustee to manage the trust assets don't vest in the trustee in bankruptcy. So. All right, so what we might do is jump straight forward and talk about superannuation, because we just talked about the fact that it's protected from a bankruptcy trustee. And so what tends to happen is, as a bit of an asset protection strategy, we say, oh, well, I've got some creditors accumulating out there. I'll just convert all my assets and we'll put it in superannuation. Now, that's always been an avoidable transaction under Section 120 and 121, which we'll talk about later, but it was a bit hard to pursue. So we had Section 128B and C, which were introduced, and basically this is designed to allow the recovery of superannuation contributions which are made to defeat the bankrupt's creditors. It effectively mirrors Section 121 in that if a contribution is made by someone who later becomes a bankrupt, to an eligible superannuation plan, and the property would probably have become part of the transferor's estate, or would probably have been available to creditors, and that the main purpose in making the transfer was to prevent the transfer property from being available amongst the creditors, then it's going to be a voidable transaction. Now, when looking at the main purpose, the court is going to have regard to the historical pattern of contributions. So if it's a contribution which is out of character, then it's a transaction which is going to be void against the trustee. From a very practical standpoint, it's actually super easy for us to pursue these claims. We just get the records of the super fund. It's easy to do. Doesn't matter whether it's a self-managed super fund. We just get it straight from the bank under Section 77C, and we look at what does an ordinary contribution look like, and if there is a contribution out of the ordinary context, then we simply identify it, and then there's similar to what Brendan was saying earlier with the voidable distributions for the anti-phoenixing laws. There's a power that the official receiver has under Section 139 ZQ to make an administrative order in relation to recovery of property, and we can do that very simply for a claim under Section 128C. So that's superannuation. I am flying through this in the interest of time. Let's jump back a few slides now to Section 120, so undervalued transactions. Now, this provides that a transfer of property can be void where the property was transferred within 5 years of the commencement of the bankruptcy, and that less than market value was received for that asset. There are different timeframes within that 5-year period that can apply, and depending on whether the party receiving the transfer is a related party. So the transfer won't be void if it took place more than 2 years before the commencement of bankruptcy, and we can't prove insolvency, or in the case of a related party, 4 years prior to the date of bankruptcy, and we can't prove insolvency. But if we can prove that the bankrupt was insolvent at the time the transfer took place, then we've got that full 5 years available, whether or not it's a related party. I do have an example coming up, so I'm just shortcutting and I won't use the examples we've got on these slides. Similarly, Section 121, so this deals with transfers to defeat creditors. And here a transfer will be void against a trustee where the relevant property would probably have become part of the bankrupt's estate, or would probably have been available to creditors if it had not been transferred, and the bankrupt's main purpose in making the transfer was to prevent, hinder, or delay property from becoming available to creditors. Anyone who's familiar with this section is going to be familiar with Cummins case, which is the landmark case on this. Brendan basically ran that file for the trustee at the time, so he knows more about it than any of us, and I haven't read it in 15 years, so I'll do a crude job of summarising it. But basically what happened there is we've got a barrister takes up chambers and goes into business for himself. And at the time, there's a property jointly owned with his wife, which he transferred to her for consideration of natural love and affection, which I'm not going to sit here and say that's no consideration at all. That would be rude of me. But certainly so far as the creditors are concerned, that's meaningless consideration. And so even though that transfer happened some 16 years prior, I think it was, him going bankrupt, the court looked at the timing, the fact that it was commensurate with him beginning a risk-taking enterprise, and determined that it was a transfer to defeat creditors, because the main purpose was to prevent, hinder or delay the property from becoming available to creditors, even though those creditors didn't exist at the time of making the transfer. They went all the way to the High Court. And there is no time limit on this, so we can look back a long way. But suffice to say, the greater the temporal distance between the transfer and the actual date of bankruptcy, the harder it's going to be for the bankruptcy trustee to prove that claim.
Couple of quick questions. So, if an injured person receives a settlement and buys a house, then later sells that house and buys another, does the exemption carry over to the second house?
Yes.
Yes. So the nature of those protected funds, they remain protected no matter how many times you transfer them, change the nature of them, they're still protected funds. And then a quick other one is, someone is making payments to their super fund and we make them bankrupt, how far can we go back to recover our funds? So the key thing is whether they're extraordinary payments or out of the ordinary course. So if they're making standard, even if it's a large amount of money every month and it's standard, it's not going to be attackable. It has to be an extraordinary payment, and
no time limit.
There's no time limit.
It mirrors this section we were just talking about. There's no time limit. We just need to show that the main purpose was to prevent, hinder or delay the property from being available to creditors. We'll just deal with this on the case, I think, in the interest of time. So this is a recent case involving our partners down in Melbourne. That's Paul, Vanessa, Matt, Jess. Matter of Lostick and Lostick. Brief background, Mr. and Mrs. Lostick were operating a business in partnership, and they had a family home. They got way behind on their tax lodgements, and then decided that they ought to bring those up to date. And when they did so in 2014, I've got a timeline here, don't I? So that they brought those up to date in 2014, and they knew that they had a very significant tax debt as a consequence. The returns related to the period from 2007 to 2013. Now, in December 2014, shortly after lodging those returns, they entered into a contract to sell their house for $590,000. There was a very long delay on settlement, which for reasons that'll soon be obvious, because in March 2015, their daughter executed a contract to purchase a property in Pakenham, which we're going to call the Pakenham property. And that was for an amount of $307,000, and the bankrupts paid a deposit of $29,700 from their personal bank account in relation to that acquisition. And then in April 2015, there was a simultaneous settlement for both properties, and there was check directions from the family home to pay the balance of the purchase price for the Pakenham property. So then in May 2015, the daughter became the sole registered proprietor of the Pakenham property, and the bankrupts moved in and they lived there. And at the time they went bankrupt, they disclosed that as their family home and the registered address for their business. So ultimately, the trustees sought some declarations here. Firstly, that the transfer of both the deposit and the balance of the purchase price to the daughter by the bankrupts were voidable transactions under Section 120 of the Bankruptcy Act, and also Section 121 of the Bankruptcy Act. And then secondly, the daughter's interest in the property should vest in the trustees. And that's pursuant to Section 139D and 139DA of the Act, which basically says that where a bankrupt contributes wealth to the acquisition of an asset that is not held in their name, but they still derive a benefit from the ownership of that asset, then it should be treated as property of their bankrupt estate. So think of a circumstance, for example, where you've got one spouse with a good income, one spouse with no income, and they purchase a property, and the property is held solely in the name of the not at-risk spouse and with no income, then that is conceivably able to be pursued under those sections. There are very few reported decisions under those sections, and this is one of the few. So when considering Section 120 of the Act, the court found that the transfer of the deposit and the balance for the daughter's property were gifts made by the bankrupt to their daughter, and that the daughter provided no consideration. The daughter argued that she didn't realise that it was a gift. She thought it was a loan, and that they were helping her with finance to buy the property, and there was that the judge didn't uphold that argument, and so the transfers were seen as void under Section 120. In relation to Section 121, the trustee had to establish the main purpose of the transfer was to prevent, hinder the property from becoming available or divisible amongst the creditors, and we had to provide evidence as to the main purpose of the transfer. Again, this was established fairly well in the Cummins case. So when considering that, the court accepted that had the transfer not occurred, the amounts which were the subject of those transfers would have been deposited into the bankrupt's bank account and would probably have been available for their creditors. And also accepted that the bankrupt sought to prevent, hinder or delay the creditors from accessing the proceeds of sale. And this was shown by the lack of consideration for the transfer or monies, the simultaneous settlements of the properties, the fact that the bankrupts then moved in, and then listing the daughter's property as their address and their principal place of business, and also critically their knowledge at the time that they had just crystallised a very large ATO debt. And then finally, the orders under Section 139DA. So when considering whether or not to make a vesting order pursuant to that section, the court was required to take account of certain matters, namely that the extent of any estate that the daughter had in the property and any hardship that might cause her. Court did consider the fact that she'd then have to move out and wouldn't be able to occupy that property, and found that that wasn't sufficient to offset the rights that the creditors ought to have to share in the proceeds of that property. Also, the daughter's current net worth and any hardship that the order they make might cause to her creditors. So, for example, if she'd gone and mortgaged the property and then had a secured creditor with a mortgage over it, then that would have caused significant hardship to that secured creditor. But those circumstances weren't present. Whether the daughter acquired the property as a result of direct or indirect financial contributions made by the bankrupts, that was pretty straightforward. And whether the bankrupts used or derived a direct or indirect benefit from the property. And in this case, they were living there, so it was held that they received a direct benefit. So the court ultimately declared that the transfers were void under Sections 120 and 121, and also made a declaration that the daughter's interest in the Pakenham property should vest in the trustees under Section 139DA. Got any questions? Or
nope, apparently everyone understands.
Well, I'm glad they do. I'm lying through it. Normally spend a lot longer on that, but it's a bit content heavy. Okay, so we've given a pretty grim summary of all the ways in which the corporate veil can be pierced and all the ways asset protection strategies can be attacked. And so you might be wondering, well, what actually works? And in reality, the answer to that question is it depends on what you mean by what works, because there is no absolute asset protection strategy. And even if there was, I guarantee your clients are going to do something to stuff it up. So What we look at instead is good strategies and not good strategies. And the good strategies are the ones that minimize harm and manage risk. So with that in mind, we've put together a list of what we think are the elements of a good asset protection strategy. The first one here is it is set up as early as possible. It's always better if the wealth which is being created is generated within the structure which you've set up to protect that wealth from creditors. If the wealth is created, say, in the individual name and transferred into an asset protection structure, like a trust or a super fund or something like that, at a later time, then it's not going to be as safe as what it was if it was set up there early. It's not to say that that's a bad strategy to transfer it later, but the sooner you get in, the safer and better it's going to be. The second is that a good structure is one that acknowledges and mitigates risks, not seeks to eliminate them. So it's impossible to eliminate all risk because there's too many variables and things are going to change. A good strategy accepts that fact, accepts that there are some risks that are worth taking and should be taken, and mitigates those risks. So, for example, when we look at Lostic and Lostic, a good asset protection strategy could have involved exactly what they did for transferring the property to the daughter. The mistake they really made was that they believed it was an absolute protection of their wealth, and they fought the trustee and the trustee's claim rather than trying to enter into some sort of negotiations and settle that on a commercial basis. They could have still preserved a lot of their wealth. So a strategy that accepts that risk and seeks to minimise damage is a good one. Adaptability is next. So if you look at that previous example and we say, okay, it was a good strategy then to transfer the property and we entered into a settlement with the trustee and preserved a lot of wealth. But what happens then if the daughter, 5 years later, starts a business for herself? She's in the sole owner of that asset. She's an at-risk person, and it's a new business, so it's a pretty high risk. So perhaps a more adaptable strategy would have been to put that property into a discretionary trust or something like that. Obviously, there's other considerations such as land tax and stamp duty and CGT benefits that may be an issue down the track, but that's something that should be considered. Review and evolution. So over time, the risk-taking enterprise will probably grow and they're going to change, and therefore the risks of the business owners will change as well. Also, the wealth that you're protecting is going to change. So there needs to be a process to regularly review and evolve the asset protection strategies. And this might be good at, say, tax planning season or something like that to go through these structures. Next, it needs to strike a balance between asset protection and wealth creation. So there's times when it's going to be absolutely appropriate to take risks like what Brenda was talking about earlier with borrowing money against the house and putting that into the company. Now that is a perfectly acceptable risk where there is a high chance of a good financial reward. So a calculated risk of that nature is okay so long as it is part of a worthwhile wealth creation strategy, and so long as also some of those mitigating steps are taken to try and protect as much as possible. So, as Brendan was saying before, to take register a security over the company so that if things go bad, the directors get their money back first. The last two sounds a little bit like I might be telling you how to suck eggs, but I think it's food for thought because these are issues that we deal with literally every day of the week when we're talking to clients that come to us for their initial conversations. So the first one is that clients understand their asset protection strategies. Now, as advisors, we have no influence on our clients' decisions when they don't first consult us about those decisions, and that's the majority of their day-to-day operational business decisions. And time again, we see clients who have great asset protection structures that were recommended and set up by very capable advisors, but the clients simply don't understand them. So the decisions they make in between visits to their advisor undermine the efficacy of that strategy. I'm sure you've all got specific clients in mind when I say that. And then the records are maintained. And as Brendan said earlier, the list of personal guarantees that people have given, for example, every week we meet clients who don't know what personal guarantees they've given. They don't know which entity owns which asset that they've acquired. They don't know whether their last BAS has been lodged, whether they are personally liable for company credit cards. They don't know whether there are shareholder loans or UPEs in their trust. And these records simply have to be maintained in order to know which risks need attention. And we often need access to that information very quickly because we're trying to help out with recommendations about how to deal with, say, a wind-up application or how to deal with a DPN with very limited timeframes in order to make good decisions. How are we going for time? We're right on 1 PM, aren't we? I can probably skip the wind-up, the summarisation page. Is there any other questions that have come in while we're talking?
A couple of questions. Yeah. There's one down here. So in relation to creditor defeating dispositions, if Newco paid for the old co assets and the transaction is voided, what happens to the funds paid by the Newco for the assets? So the way all voidable transactions work is the transaction is void, so any consideration has to be repaid as well. So if you bought $1 million worth of assets and Newco has paid $100,000 for it, they have to give that $1 million worth of assets back, but they'll also, when those assets are sold, receive their $100,000 back. So it's a complete voiding of the transaction.
What you might do in that circumstance, though, before there's any decision about whether or not there's been a voidable transaction, is just offer to settle the claim with the liquidator. And going back to what I said about good asset protection strategies, that's a pragmatic solution, and you're really looking at pragmatism over idealism in a lot of these circumstances.
So how much protection is there if directors take on management-related insurance? Look, that's probably a question for an insurance broker, but generally, I've yet to see one of these policies respond in an insolvency style situation. Most of them have carve-outs, so if the business becomes insolvent, they immediately don't respond. And a lot of them won't cover things like insolvent trading claims or voidable transaction claims anyway.
Breach of duty.
Yeah, or breaches of duty claims. So they're not super useful in this situation from my experience. I think Aaron's probably...
Yeah, like all insurance policies, they carve out the real risk and charge you a lot of money.
And for property held on trust, what has less exposure, a fixed trust or a discretionary trust?
Discretionary trust.
Probably a discretionary trust, yeah.
Yeah, so with a fixed trust, if a person who is a beneficiary of a fixed trust ends up bankrupt, then any entitlement they have to distributions or assets in that trust vests in the trustee. Whereas if it's a discretionary trust, there is no title, there is no entitlement that can vest. So typically a discretionary trust is better.
That's all the questions I've got. If anyone else wants to type a question in, we can give you a minute, I suppose.
I guess while we're talking about that, if you haven't filled in that survey for us, it's on the right-hand side there. Just click survey and then click what's the next thing it asks. Take survey.
Yep.
That's really useful feedback for us to help improve our website.
Yeah, there'll be a email going out after this. There's a companion booklet that goes with this presentation, which just summarises what we've been through and also includes an asset exposure checklist that you can go through with your clients. So there'll be an email coming out with a link to download that paper. All right, looks like there's no further questions. So thanks everyone for coming.
Thank you, everybody. We'll see you next time.